I want to thank Scott Bovitz, our chairman, and Wes Avery, a board member, to put this program together, prepare the outline, and organize the judges, the fine judges we have here this morning. Just a quick pitch for the ABC. If you're not a board-certified attorney, I would suggest that you might want to consider doing that. It's a great way to get recognition for your skills, reputation, ethics, which is what we're talking about today. Because I will tell you that no board-certified attorney has the problems we're going to be talking about today, I hope. They won't be certified very long. And we have a booth just around the corner, manned by two of our staff people. If you're interested, you can pick up literature. I've been board-certified for, gosh, almost 30 years. I think I took the second exam that was given. And I believe all the judges here are board-certified at one time or were. So it's a great tradition. It's a great thing to add to your resume, and I hope that you'll all consider it. A disclaimer here, the opinions expressed by the judges here today are their personal opinions and cannot be used against them in a court of law. That's right. I'm going to ask each of the judges to kind of introduce themselves and tell us a little bit about their court or something about themselves quickly.
I'm Buddy Oldshoe. I'm a judge down in Mobile, Alabama. Scott had asked us to speak a little bit about our court. I don't know if any of you have ever been to my courtroom, but it's in an old bus station and has been for about 20 years. Thankfully, we're moving into the U.S. They built a new courthouse in Mobile, and we're moving into the 1932 courthouse after it's renovated. So we're really excited about that.
That's because debtors always come and go.
That's right.
I'm Jim Tancredi from Hartford, Connecticut. There's 3 judges that sit in Connecticut. I've been on the bench for about 3 years after practicing 38 years as a commercial litigator and restructuring lawyer. I'm happy to say I got a fairly good balance of cases in my court. There's about 25 middle market 11s, and I've learned how to be a good shepherd on Chapter 13s.
I'm Madeline Wansley. I'm a bankruptcy judge in Stock. Can you hear me now? There you go. All right, I'm Madeline Wansley. I'm a bankruptcy judge in Phoenix, Arizona. I've been on the bench for just about 5 years. As practicing lawyers, one of the things that's good for us is to know our judges. You can always tell your client what to expect generally. And in Arizona, we had all 7 of our bankruptcy judges turn over in about 16 months, throwing our bar into chaos. So that's something unique that happened in Arizona. But I didn't know we were going to talk about what we did. But I am, I was a practicing lawyer for 23 years before joining the bench, and I was with the same firm that entire time.
Troublemaker.
Excuse me.
I just said she's a troublemaker.
Yeah.
I'm Dave Hersher. I sit in Portland, Oregon. I have 3 colleagues there. I practiced for 35 years with one firm, so this is also my second job since law school. And I think what's unique about, well, not unique, but what I think is somewhat special about our court is we're a tenant in a private office building. We're not with the district court. And we always think that that's an advantage. The courtrooms are very nice, but we think they're more approachable and personal than the majesty of the high-ceilinged courtrooms over at district court, and we think of our court as a people's court. We want to make it approachable and accessible to debtors, especially the pro se debtors.
Good morning. I'm Jim Carr. I sit in Indianapolis, Indiana. I'm going to win the prize. I was 38, almost 39 years at the same firm. It was called Baker and Daniels for years, and now it's called Faegre Baker Daniels when they merged with the Faegre and Benson firm of Minneapolis. I've been on the bench. This is my 7th year, so I'm really, really old if you do all that, if you add those together. Our courthouse in Indianapolis is gorgeous. It was built as a horseshoe when it opened in 1909 or 1911, and then during the Depression as a WPA project, it was completed as a rectangle. But it's all, beautiful Bedford, Indiana limestone and marble inside. I was surprised to find out recently as I was talking to some people around that in so many places the district courts and the bankruptcy courts sit in different buildings. In our building, everybody's in the same building. The bankruptcy courts, there are three of us, the district courts and the magistrates, and we all get along well together. You want me to talk, or are you going to
No,
start?
I'm good. Yeah, I was
guess
waiting
the
to
one
see if you
thing
guys had
the
noticed.
one observation I made already is I don't see anybody here that practices my court. Is there anybody here practicing my court? So I can say anything.
You know, one of the fun things about getting you all together is you get a chance to talk to one another about different practices and how you do things. And boy, there's a lot of fun stuff with respect to lawyers breaking bad, right? And so it's nice to have a lawyers breaking bad program. That's what this is, Ain't Misbehaving, and it's about stuff that may fall into your court, and we may see a little bit. Wes Avery here is a trustee, so he's out there not only trying to collect some dough, but to sort of hammer home good behavior. Robert Furr, same thing. I'm a bankruptcy litigator, and you know, occasionally I have conversations with people that I don't like to share, but I like to learn something and maybe guide them the right way. And so we've got some law and we've got some examples of particularly egregious behavior, and we're going to sort of talk about it. Mr. Avery, we're looking at slide 4, debtors' transactions with attorneys. You're going to file a statement of compensation paid. Why are you going to do that? Why does a debtor's attorney need to do that?
Before I begin, I've got a disclosure. My immediate supervisor's here from the U.S. Trustee's Office.
Oh, no.
And we're going to be talking about the interplay today between the court, the U.S. Trustee's Office, panel trustees, and debtors' attorneys. To start off with, the 329 statement gives you some idea of what's going on in the case. In the Central District, we have an unofficial rule that a Chapter 7 debtor's attorney can't be paid more than $5,000 retainer.
That's outrageous.
Right. And if so, then as the number gets higher than $5,000, inquiries begin. But it's nice for the Chapter 7 trustee to see what's at issue here, because if there's a $15,000 retainer, obviously there's $15,000 worth of work to be done.
Wes, you're going to have to put that microphone closer to your mouth because the people in the back are snoozing off when you're talking about that, so clearly you're not loud enough. Slide 5, 11 U.S.C. Section 329. Wait a minute. That applies in every chapter, doesn't it? Right? Chapter 3, Chapter 5, not Chapter 7 stuff. Any attorney representing a debtor in a case of this title, okay, I guess that's the Chapter 7 case or 11, in connection with such a case or in connection with such a case, which I guess is pre-petition planning. Did you go to that pre-petition planning program yesterday? It was really quite interesting. Whether or not you're going to apply for compensation shall file a statement of the compensation paid if the payment agreement is within a year. Okay, and the source of such compensation. Mr. Avery, do you see the source of compensation listed on those statements that are filed?
Typically
Stand
not.
up. Stand up. You're on. Look at this guy. Look at this-
Typically not.
right there. You're looking really good.
Typically not.
Okay. Federal Rule of Bankruptcy Procedure 2017. Payment to a transfer on slide 6. Payment to a transfer order for relief on motion of a party in interest. Okay, I guess I know what that is. Or the court's own initiative. The court, after notice of the hearing, may determine a payment or money or transfer of property is excessive. Judges, do you struggle with the issue of doing the things that the code says you can do on your own? I know Judge Hersher has a strong opinion on that.
Well, I have an opinion as to whether or not it's an issue generally, but it helps when the national rules or the code tell me that I have authority, then therefore I don't have to wrestle too much with the question of whether or not it's improper for me to act on my own. Now, in this particular circumstance, I have not had circumstances that have caused me to exercise my own initiative, but I feel comfortable that it would be proper to do so.
Yeah, you know, I don't know if it's the same every place else, but the great mass of Chapter 7 cases, and you know, it's got to be over 90%, come and go, and I never even know that they happened. They only come before me when there's an issue that somebody. So I mean, I don't scour. Does anybody scour your Chapter 7 petitions and schedules. I don't. So it would be hard for me to raise an issue. Same in 13s, because I was a Chapter 11 lawyer. I thought 13s were mini Chapter 11s, and we were going to have confirmation hearings, and I kept waiting for the confirmation hearings to happen, and they never happened. So once again, the great majority of those cases come and go, and I never even know what happened.
So here's a way that it can come up, and that's in the situation of a repeat filer. You know, when we have a successive bankruptcy filer, they have to seek authorization to extend the stay. And that's the point in time in which you can look at those disclosures. In our district, we have in Chapter 13s the presumptive no-look fee of $4,500, $5,500 if it's a business case. And so if I see maybe a case that was filed 4 years ago, $4,500, 2 years ago, $4,500, a year ago, $4,500, and now I have the fourth case, but again, they don't lose the stay because it's been enough time that's passed, and they're looking for their fourth large fee, and it's the same law firm, I might have a problem there. So that's how it might come up.
Judge Wansley, how are the fees paid in 13s in your district?
Well, generally, probably like most districts, there's a retainer that's been paid of some amount and then paid through the Chapter 13 trustee. But those cases get dismissed.
But are they paid first?
Right. The fees get paid first, and so the case gets dismissed after the fees have been paid. So I have had debtors come before me, and they've had the same attorney who's now received, $12,000, $15,000, and they've never had a successful Chapter 13. And so at that point in time, we talk about it.
It's like Rumpole of the Bailey. You have a family that's a criminal family, so you always get repeat work.
Timson's.
Yeah, that's exactly right. I love that stuff. So you're saying you might run across it on your own. Your clerk might bring it to your attention, and then what are you going to do? You going to file a motion, or you do an order to show cause? What do you do?
Well, the situation which I've described, we have that conversation in the courtroom when they come in to extend the stay. I say, let's talk about the case. Let's talk about why the stay should extend. And counsel, let's talk about your fees. And what I've had so far is counsel agreeing to reduce their fee or not seek fees in the current case. So we've had just sort of a nice conversation and a resolution. But I would consider issuing a motion if I had seen that situation.
One of the things we do in Connecticut more often now than not is when there's indicia of that, in connection with the dismissal, we'll retain jurisdiction to make sure we pass on the fees and get the whole story.
Can you hear that quiet talking judge in the back?
Okay.
Okay, that's good.
These microphones work.
Former Judge Markell in the back. We're expected to hear from you later.
What about special counsel fees? Do y'all take a close look at those?
Yes, both on the front end and the back end. As you know, oftentimes the norm in the jurisdiction is that special counsel have their own retainer letter, and oftentimes those retainer letters are inconsistent with provisions in the bankruptcy code. They have sometimes authority to settle in them. They have sometimes ability to get indemnities, and those kinds of provisions get scrutinized and stricken.
Are we talking in the Chapter 11 framework?
I see that both in 7s when the trustees retain special counsel and 13s as well.
Yeah, most often in the consumer area, they're retaining special counsel to pursue a personal injury action, or in the vast majority of their contingent fees, and they usually follow the convention for contingent fees, so they don't cause me a lot of heartburn.
Morocco, you awake? Are you the world's expert on debt relief agencies?
No, I think no. But I did know nothing about them.
You are now.
So what do you do for a living?
I go after bad attorneys and petition preparers.
Would you like to stand up and spend 60 seconds and talk about debt relief agencies?
I am not authorized to speak at this conference.
But he's authorized to speak in court a lot. Debt relief agency. Avery, what's the big deal about debt relief agency, slide 7?
Well, if you're looking at the slide, I guess the key words are assisted person as any person whose debts consist primarily of consumer debts. So you've got the consumer debt test, plus the value of whose non-exempt property is less than $192,450. So really,
Actually,
by
went up on April 1st, so a little
yeah,
bit.
so by definition, you're talking about much small, or the smallest cases.
Okay, well, if you're a debt relief agency, you got duties, right? You gotta say all this stuff and reveal it, and we don't like it, and that's really kind of terrible stuff. But maybe I look at it a different way. It's a moniker for advertising. Official debt relief agency, set by Congress, right? And if you're a debt relief agency, you shall not counsel or advise any assisted person with something to make a lie, to mislead the court. We have these cases that talk about your 90/11 rules. We don't need that. It's right here. It's a statute. It says if you're a debt relief agency, so I know that's a consumer case, right, that you can't tell someone to lie. We have a case later in the materials that talk about a lawyer, allegedly, told the debtor not to list the horses.
Yeah,
That's
but we
the
need
Quink case.
9011 because this only governs debtors' lawyers. So the creditors' lawyers get covered by 9011.
Well, a creditor lawyer would never advise someone to lie. Right, Judge? Slide 9, 11 U.S.C. Section 526, so we're talking Chapter 5, so it applies to everything. Okay, a contract for bankruptcy assistance between a debt relief agency that doesn't comply with these requirements. Mr. Avery, what are these requirements? The 527, 528 stuff.
What it does is it talks about disclosures that have to be made to the court, among other things, in terms of what is the scope of work going to be. Will adversary proceedings be covered? Will they not be covered? Will they attend the 341A? Will they not attend the 341A?
It is what's interesting about this to me is it does only govern the debtors' lawyers. It doesn't protect not only the court, but creditors from things that happen to them. And one of the phenomena we're seeing, and I don't know if you're seeing around the country, there are now firms that go to just unsecured creditors who are scheduled and say, we'll file a proof of claim for you, and they charge them outrageous amounts. They charge them a percentage of recovery. You're seeing this around the country, and so in our court, we've been asking ourselves, how do we police this? Where's our authority to police the fact that some dumb creditor is paying somebody to do something that their child could do?
But it's hard if you don't have a claims agent to figure out what to do. In the Central District of California, they've got a sort of a whole page that's web-oriented, and you can fill it in, and you can do stuff, and that's now kind of a new thing. Avery.
Judge Carr, that's become a very big business.
Yeah, that's what we're grasping in Indianapolis. It's creeped in there.
Also, Chapter 7.
So what do you do about it? If it's big business, what is it the judge's role? Is it the U.S. trustee's role if they see that creditors are being taken advantage of by these firms?
Well, I don't know how much they charge, but these clearinghouses are trustees' best friends. Often we have situations where someone files a petition to get the stay and doesn't file schedules. Don't show up at the 341A, but we do a background search and we find assets. So we go knock on the debtor's door, say, we'd like to see your house.
Wait a minute. If somebody files a schedule because, gosh, we just want to delay that foreclosure for a week or two, and we don't fill in a petition, doesn't the clerk automatically dismiss the case? I know in the Central District that would happen, so
Yeah, so
what are
what
you
happens
doing?
is to stop the dismissal, I immediately file a notice of asset case, and we call the clerk of the court and say we're going to be administering assets. Now what comes up is a situation where we have to find creditors, and this is where the clearinghouses come in.
So it's good work, Judge. So the fact that some, maybe not a lawyer, is helping out, maybe that's okay for now, but it's going to be replaced by some web interface?
Yeah. What we're just now seeing and worrying about is it would appear that these firms are getting the schedules, they're finding out who's been scheduled, they're contacting them and saying, let us file your proof of claim for you. And it's, this is a pretty ministerial act, the proof of claim filing, at least in our court. And they're charging them substantial fees. I think most of them are percentage of recovery type fees.
Are they lawyers, Judge?
No.
So
Is it the unauthorized practice of law?
That's what I was going to ask.
Yeah.
So either it's the practice of law and they are not lawyers, so unauthorized, or it is the practice of law and it's an ethical violation because they're contacting people with whom they had no prior connection. So either way, I think it's a problem.
First Amendment, Peel. I can send out a solicitation to someone. I certainly could do that if they were debtor-to-be. I see you're in foreclosure. I'm a lawyer. You know, we might be able to slow it down. I can probably do that, even though it's commercial speech. Maybe. So why couldn't I go out and charge people an well, okay, maybe not an outrageous rate, but a rate to do that?
What if it's a contract for assignment?
Well,
Just they've assigned the entire claim.
That's a whole different problem, which is we see people filing amended proofs of claim in lieu of filing the documents you have to file when a claim is assigned to you.
Is that to save the fee for assignment?
Save the fee, yeah.
So, who are you?
Richard Carmody. I preceded you. I took test one. No, that's all right. Why is it the practice of law to file a claim when you said that your child could fill out the thing?
Well, my child's a math major.
I have trouble with that.
I think the case law is pretty clear that it's not.
Yeah.
It's a ministerial act.
What about the judgment about priority and theory and what the attachments need to be?
503B9.
But I think there's a question, if you have a non-lawyer working for the creditor who wants to prepare and file a proof of claim, that's okay because it's not the practice of law and they don't have to hire a lawyer. It's another thing for somebody other than the creditor to contact the creditor and say, I'd like to assist you in filing a proof of claim, and here's the nature of your claim, here's the priority of your claim, here's the legal effect in terms of waivers that could result from filing a claim. That could be the practice of law.
Yeah, I guess the general question, the broader question is, we've got a lot of stuff here that allows us to regulate people who represent the debtor, petition filers, lawyers. We have no explicit authority that I know of to regulate people who are representing creditors. And
You know, in Florida, we have a very strong Florida unclaimed funds statute. It's called the Florida Treasure Hunt, and you can go on a computer and see if they have any money in the registry of the state that from a bank account or a personal injury claim or something like that. And in my trustee practice, I'm always getting find out those kind of properties. I get letters from people who purport to be accountants, lawyers, agents wanting to be my representative, and they'll take a third of it. All you got to do is go online and fill out the computer form, and they'll send you a check if you're the right person. So it is a business that's similar to this. I'd never heard of that before. It's very interesting.
I don't think we have the tools to address that in the code or in the rules. If it's a problem that's going to need to be addressed, it's going to have to be handled legislatively first.
Judge Carr, some major banks have been instructed not to file proofs of claim for political reasons. So sometimes when
well, they don't want to submit to the jurisdiction of the court.
The other thing is that we've been approached from time to time by businesses that want the estate to pay for them to go out and find claims, and that's obviously a non-starter.
Judge Carr, do they add those fees back into the proof of claim? They try to collect those additional charges they're making?
This is a brand-new phenomenon. Literally, in the last few weeks, my colleagues and I have been looking at this. So far, we've punted it to the United States trustee because we looked at each other and looked at the code and didn't see where we had authority to get involved. I don't know what the United States trustee is going to do.
Right.
That was our immediate past chair, American Board of Certification, Mr. Gino, who did a fine program. Here's some place on slide 11 that you do have some explicit power and authority, not over everybody in the world. The court, on its own initiative again, or on motion of a party in interest in accordance with certain procedures under 9011. Well, that's kind of interesting, so I guess I got to send a notice and wait for them to respond or something like that. May order the attorney for the debtor to reimburse the trustee, well, that'd be Wes, I guess, Chapter 7, 707, for all reasonable costs in prosecuting a motion filed under 707B. 707B, Avery, what's that?
That's a motion to dismiss for abuse of the system. I notice we have Judge Barrish here from the Central District, and I practiced before him. Typically, this is done by the U.S. Trustee's Office. Typically, at least in the Central District, Chapter 7 trustees don't get into filing motions to dismiss and/or motions to convert. And I guess one reason why is if you string it out, you can get the clerk to dismiss the case. Chapter 7 trustees can get the clerk to dismiss the case, so you don't have to make a motion.
If the court finds that the attorney for the debtor, on slide 12, violated 9011, okay, the court on its own initiative, okay, or the motion of a party, may order the assessment of an appropriate civil penalty against the attorney for the debtor. Oh, I don't like that. The payment of such civil penalty to the trustee, what do you do with that money? Avery?
I've never done it.
Hey, Scott, what about under 9011, you're supposed to send a 21-day notice that you're going to bring an action under 9011? You've got that requirement. Is the U.S. trustee doing that?
It seems to me, because it refers to 9011, that, right, there has to be some notice and an opportunity to withdraw. And I know you're not authorized to speak, but has there been any historical effort to do that?
If I recall 9011 correctly, filing a petition is an exception to the safe harbor.
You're right. That's one of the exceptions for filing a petition. But other 9011 issues, you have to send a 21 day. You should send a 21.
You son of a gun, you haven't read the code, take it back, right?
That's right.
Okay, but the signature on an attorney, slide 13, that includes a petition. It says right there, a petition shall constitute a certification. I'm not sure what that means, but I think it means that it's really, really important or right or something. The attorney has performed a reasonable investigation into the circumstances that gave rise to the petition. I met with those guys for 15 minutes, pleading a written motion. I determined the petition was well-grounded in fact. Well, they got a foreclosure coming up tomorrow, is warranted by existing law or good faith. Well, they told me they hadn't filed again recently. Is that enough? Avery, is that, what's going on? Judges?
Well, it's very
It's a
easy.
nice face you have.
Yeah. Well, we talked about this beforehand. There's obviously a duty of verification, and the question is, what is the appropriate threshold of inquiry to satisfy that duty?
I'm charging $900, okay? How can I?
Your business model is not my problem. My problem is what the law says, and the law says you have a duty of verification. And I think that means at a minimum, you probably have to do things like a UCC search and a title search, and where the debtor's information is less than clear, dig a little bit to get those documents.
So how are you going to enforce it? I mean, you ask each attorney about the investigation they've been doing?
When it comes out in the middle of a hearing that lawyer didn't do a title search, then I reserve judgment on whether or not it's appropriate to sanction or to otherwise reduce the fee before the end of the case.
Well, the other
The new
problem,
judge speaks.
The other problem with this, so look at it this way: if a Chapter 7 trustee will only get $60 and they're motivated to do some due diligence, if you're going to get $1,000, it doesn't sound like a lot, but you should probably do some due diligence as well.
Go on Facebook?
Well, more than Facebook. But the thing it comes down to is credibility. Because if you didn't do a good job and you didn't do your due diligence and you get caught, the next case you bring to the judge, probably going to take a deeper look at it, probably going to spend a little more time on it. And so that impacts their overall credibility, overall professionalism, and the way your case is processed before the court. So there's a bigger reason to have that due diligence as well, to do a good job, right?
I think the thrust of 707B, 4C, and D, at least as it regards the petition, is the effort by the code to make as many people as possible file 13s as opposed to 7s. So the real question is, did the debtor's lawyer do enough to determine whether or not the debtor really could file a 7? And if somebody's in that practice, they know that they know all about that. So if people are trying to slide them through, I think that's a serious problem, and it's not going to last very long before it comes before us.
And you know, business models are not excuses. Technology has moved at the speed of light. There are technology tools, whether it's a Google search or a free title search that is now available in many states online. You have to adapt your business practices to embrace technology and efficiencies.
So if I search by Wes Avery or Wesley H. Avery, that might be okay, but John Smith or whatever might not be as simple to do what you just described, because now I got to figure out who it is, right? It's complicated.
It is
It
complicated.
is complicated.
Yes, sir. I don't know you. Hi, I'm Scott Bovitz.
Hi, Scott. I'm Neil Sater from Kansas City. And I'm going to give you kind of the flip side of my thought on this. I've been practicing consumer law and, well, kind of a bankruptcy boutique firm in Kansas City. At any one time, I've got about 300 cases, 13s going at any one time in my office, plus another 50 to 70.
Mr. Furr, would you bring him an application to become a certified specialist? Oh, thank you.
No, but here's the flip side, Your Honor, judges. And the flip side is, you know 90% of my debtors, I think, are honest, hardworking, well-intentioned. They don't call me for nefarious reasons. They call me because they need me. Right. And they call me sometimes 2 days before, 3 days before. I get it. And I have them in. My attorneys, we're not a chop shop. They meet with their attorneys. Their attorneys handle every case. But I'll tell you, 9 out of every 10 of these cases, the people are good, honest. We get the information. They're up front. It's filed for the right reasons, and I can't do all that work for the fees that we charge that you're talking about, Judge Tancredi. Mm-hmm. And effectively, I think, because I'm then penalizing the 9/10 of the cases that I think are appropriate, and that as a 30-plus year practitioner, I know I'm doing the right thing, and if my clients are less than honorable, I know every once in a while that's going to sneak by, and that's part of the system, but I don't think I should be held responsible for it. But if you're having me hold to a standard that I have to apply now to everyone, these extreme standards I think that some of these rules require, I think it is really, denying the process that we all intend, and that, every once in a while, the guilty guy gets away every once in a while. That's just the way our system is built. We don't penalize the honest people because of the, periodic guilty one so much. It's kind of a balancing test. And I would just like to throw that out and say that, I don't think that we can, despite technology and everything else, apply rigorous standards to every one of our cases.
I don't think I'm suggesting rigor.
Discuss.
Proportionality and some level of diligence so that you can, on a bona fide basis, verify. And while I agree with you, I think most debtors are, in fact, honest. There are some that are desperate. There are some that are disorganized. There are some that are in a corner. And if there's not some check and balance on that, the system doesn't work.
I think most judges, I hope most judges understand that this statute isn't pure. I think that's pretty clear. And there's been a lot of lobbying over the years. And so one of the things I find troubling is you can get in trouble if you file a 7 for somebody that should be in a 13, but you really don't get in trouble if you file a 13 for somebody that should be in a 7. Mm-hmm. And at least there's no explicit rule. And I always take that, and I agree with most of what you said, almost all of what you said. And I think all of us have a sense of proportionality and understand the economics of debtor lawyers and how they're getting paid.
I was just going to say that it's
judges before we move on. How many of y'all have actually, on your own motion, entered an order under 707B4A?
Never done it.
They never come up?
Yeah, me either.
Yeah. So the power is there, right, because of the court's own initiative, but it doesn't come across as a practical matter. And this gentleman who was a certified specialist, has spoken to say, look, this is the question. We have slide 15. What does no knowledge after an inquiry, that it's incorrect? It's kind of double negative, but you more or less say, I think it's right. That's what your signature should always be. Right. That's what you should be as a matter of business, right? I want you to know that if I'm coming in and I'm saying something, I think it's right. But I'm also saying, hey, as a practical matter, he represents 300 people and 95% of them are good. That means 15 of his people are cheese balls, right? And he doesn't know about it because he wouldn't bring it before you. What's your comment, sir?
Well, there's two comments.
I'll hold the mic.
The first comment is that I would say to Judge Carr, lots and lots of people file Chapter 13 that should be filing Chapter 7, and some of it's
So they can pay their lawyer.
No, well, no, maybe to pay the lawyer, more than the lawyer would get paid in a Chapter 7, not necessarily to get the debtor any more relief than they would otherwise get. Frequently racially motivated. So
I agree with you. That's
so
what
that's
I'm saying.
something that,
I think too many times that's the abuse, is that people are put in 13s that should be in 7s.
So I take exception to that one, but I think you all know that. The other point, though, is that following the counsel's comment earlier, I don't think that lawyers are called upon to audit their clients. You know, we have auditors that are supposed to be doing that, and they do that on a 1 out of every 2,000 basis. I think that you want to maybe test. That's fine, but you're going to test everything in every case? No, that's not acceptable. A Chapter 11 lawyer wouldn't audit schedules before he files it or she files it. A Chapter 7 lawyer shouldn't have to audit schedules before he or she files it. Test, yes. Check things on a test basis, of course. You see a problem, then check further, but you can't expect it to audit every particular case. That's not the scope of the duty. That's not the duty of care either, I don't believe.
So,
Well, and I
Judge
don't
Briggs.
think it's an
Nope.
audit, I don't think it's an audit type process. It really is just, you know, bankruptcy is all about transparency and to make sure you have sufficient information so that you can make the disclosures that are required. And if something doesn't feel right, then you investigate a little bit more. And I think if you're successfully handling that many cases a year, you know, you're doing it right, right?
You know, there's different standards of practice. You can do the minimum standard of practice to keep your license. That's one thing. Or you can practice at a higher standard, which is what I try to do. And I do audit my clients. I do check their backgrounds. And then I've handled thousands and thousands of Chapter 7 debtor cases as a debtor's lawyer. I've had one not get a discharge. And I had one recently that almost didn't get a discharge, and I fought and fought and fought for him at no compensation because I like my record. But I can say to people that I get you discharges. And I do it because I practice at a higher standard. I think that's what a certified lawyer, which we hope you all will be, will think about doing. And I think that's something to strive for.
Scott? Scott? I'd like to interject that I think that we've been talking a lot about debtors who are intentionally misrepresenting things on their petition, but my sense is, certainly from my experience, short experience on the bench, and from what I've read, is that the majority, if not the vast majority, of disclosure problems are either innocent or negligent on the part of the debtor. The other observation I have is that, you know, obviously we have to give meaning to the statutory changes that were made in 2005. And when the Congress added a requirement for reasonable investigation or no knowledge after inquiry, I think that's got to mean something other than asking your client and having your client say what their assets are. I think there's a lot of circumstances. There was a discussion at a prior program here where clients have a various level of sophistication, and somebody might not understand what a trust is. They might not understand what present ownership of real estate is. They might not even know that a parent has transferred property into their name, which to me all suggests that there needs to be some general understanding of whether or not there's some base level of third-party investigation the debtor's lawyer is going to do and not just take the debtor's word for it. I was surprised to hear from the debtor's lawyers in my district that they don't routinely conduct any kind of real property search before filing. It seems to me that the technology and the low cost of a basic level real property search is such that it probably ought to be part of the base level of service that's provided in every 7, especially because clients don't understand. A client might, for example, think that because a foreclosure judgment has been entered that they lost their house, when in fact the sale had not yet occurred. Client might think that because they have a mortgage that they don't own their house, that the bank owns the house. There's all sorts of reasons why unsophisticated lay clients might not appreciate the correct answers to the technical questions on the schedules, and why the lawyer needs to take independent action to inquire on some kind of basic level of public sources and not take the debtor's word for basic things like what real property do you own.
Judges, you agree?
Yes.
Yes.
Can I ask one follow-up on that? On real property, Your Honor, I come from an area where I'm in a bi-state area, but there is no uniform way to check for real property records. There's one county that's got property records online. All the others in the 6 or 7 counties that I practice in really aren't online or available, at free or public access. I'm not sure what you're suggesting. Are you suggesting we all order title reports?
It may be different from across the country, but I know where I sit, it's all electronic. So we can look that up at our desktop.
So can we in Connecticut? Yeah.
Where I sit, each county differs, and it's not all available free online. But the title companies for $100 or $150 can give you a statewide search that just identifies property. It's no insurance, and it's a basic report, and it'll cover an entire state.
So what does the U.S. trustee say? Oh, sorry, this is not an official comment.
But one of the situations you do tend to see, and this is a simple pacer check, where you see a debtor filing their second Chapter 7 case 7 years, 11 months out, and had the attorney looked at the actual pacer docket and found the prior case, they would have waited on filing it. So that's one of the situations that does come up pretty often, actually.
Yeah, one of the things that we see in Indiana, we have ownership by a husband and wife as tenants by the entireties, and we have the concept that neither spouse has an interest in the property. It's the couple, which means that if somebody gets a judgment against one spouse, they don't get a lien on that property. And too often, I've seen lawyers filing motions to get rid of junior liens, junior judgment liens, and the answer is it never attached because it's entirety's property. And we have, and I'll probably refer to it several times as we go along, something called Rights and Responsibilities of Chapter 13 Debtors and Their Attorneys, which lays out what you're supposed to do in some form. And it doesn't call for an audit. But the quid pro quo here is if you do this, then in our 13s you can get a no-look $4,000 fee. If you sign this, agree to do these things, and perform. But the one place that's one place where I think the lawyer, when he meets with the debtor, should be asking, when you bought your house, did you put it in both of your names? Or is it really, if only one debtor is filing? Or even if both debtors are filing because that judgment lien did not attach.
So we have a 6-judge panel. Judge, what is your thought?
So it seems to me that this question of how far the debtor's attorney needs to go in inquiring, is this on, depends in part on what the debtor's attorney knows already. And this comes up in my district a lot when Chapter 7 debtor goes through, files a statement of the schedules and the statement of financial affairs, and in the SOFA discloses pending litigation, and there's a part of the form where you have to indicate the status, and the status may say something like judgment issued. Okay, case closes, no asset case, discharge granted. 7, 10, 14 years later, the debtor comes in with a 350 motion, reopen the case, let me file a 522F to seek to avoid the judicial lien. And, I haven't been terribly receptive to that when the lien is the product of a judgment that was on the SOFA, And so the question of how far you need to go, I think, is answered in part by what you know at the time. And, I'm not terribly sympathetic when the debtor's lawyer says, well, Judge, I didn't do a title search, and there are 16 counties in Maine, and, Worcester County's a long way, and I don't want to drive. And I say, yeah, but what about the judgment that you knew about when you filed the schedules?
But are you punishing the debtor for the debtor's attorney's lack of effort?
Well, I don't know if I'm punishing the debtor, but, the debtors come to court with their lawyers, and they pick their lawyers. And so,
I would grant that and punish the lawyer by denying fees at a minimum for it, but I wouldn't punish the debtor for that lawyer error.
How does the creditor have a legitimate opportunity to test valuation 14 years later?
Well, that's a fact they can raise in response to the motion. They can raise latches if they wish, but they usually don't respond. But I'll hear the motion. Anybody else want to?
I needed to leave the mic with the judge, who's also a certified specialist. Yes, sir. Mr. Bolts.
I'm in North Carolina, where we also have tenants by the entireties, Judge. But, and one of the things I think that often happens is that the bench, and this may be due to inartful pleading, doesn't know what's actually going on. Because, yeah, it's unnecessary. There's no judgment lien attached, but the title insurance company won't allow that refinance or that sale, and the client is screaming, and the real estate attorney, guess who they always blame first? The bankruptcy attorney, because we're the losers of the bar, all right?
Yeah.
And so we filed a motion either to get a comfort order or to just get something there.
And I agree with that, but the motion then needs to say, this is entirety's property. I mean, I shouldn't have to ferret that out, which is what happens. Somebody will file a motion asking to remove a junior lien, and between me and my clerk, we say, well, who owns this property? You know, that the debtor's lawyer should know that, is my point.
Let's set the record straight. Bankruptcy lawyers are not the losers of the bar. They are good, decent, hardworking, and intelligent professionals.
Thank you very much.
Doing
Hold that
important
question
work.
for a second.
That's right.
Do any of the districts have a local rule that delineate the quantum of verification? Okay.
Okay, we're gonna skip ahead to slide 21, Withrow, because this is kind of a fun case that came out of Massachusetts. Mr. Avery, talk to us about that.
This is a Judge Boroff case. This is the situation where a client comes to you and you decide to file a Chapter 13, and you file an emergency petition, and you've got all your numbers loaded, and you've got it all the numbers to favor, disposable income, so you can fund a plan. Then you make the change. The client doesn't want to go through with the 13. You want to convert to a 7, yet you don't change the numbers in the computer. Oops. So now trouble ensues. So what happens is at the meeting of creditors, the Chapter 7 trustee begins by saying Schedule C hasn't exempted the residents of the automobile. Counsel promises that he'll do so.
I'll do that right away.
At this point, somehow the debtor's overtime becomes at issue. And this is getting back to the idea that this was intended to be a 13, and now it's a 7. The Chapter 7 trustee in our district, Ron Morocco, U.S. Trustee's Office, would be doing this, but here the Chapter 7 trustee goes after debtor's counsel. Debtor's counsel prepares and files an affidavit signed by the debtor re the overtime issue, which inter alia declares that the amended schedule has been filed when they have not. As fees mount, counsel makes a bad decision and decides to go in for interim compensation. Now, this is interim compensation from the debtor, but I guess this is a bad debtor's attorney. He's under some kind of prior order that if he gets paid by the debtor, he's got to seek permission of the court before his client can pay him. At this point, the U.S. trustee jumps in, and it comes to light that the amended schedules haven't been filed.
Okay, so that raises some questions. Wait, OSC, talk about that. Counsel testified that the omission was due to the fact the debtor didn't provide monetary support, but there's inconsistent testimony. Avery?
This testimony was inconsistent with the debtor's response affidavit. So at this point, the court's looking at various documents filed with the court, and none of them match as to income.
Okay, so this raises on slide 23, judges, really easy lob questions, right? Counsel prepares an affidavit, and he says that I've filed amended schedules, and that ain't so. Does that disturb the court?
It's about the worst thing a lawyer can do is make a knowing misrepresentation to the court, which I haven't seen, but if I did, I think I'd have to look hard at whether or not it should be investigated for a suspension or disbarment.
Yeah, I mean, I always say the same thing, which is consistent with what a lot of people have said. Most of the lawyers that practice in front of me are tremendous, and I can take whatever they say and go to the bank with it. And it has to be that way because, particularly like in the Chapter 13 world on Tuesdays, I have to hear somewhere between 50 and 100 cases in an hour and a half. And, I can't stop and verify everything somebody says to me. So most of the lawyers that practice in front of me on a regular basis. If somebody starts to lie to me, they're done. I mean, because I'm not going to take what they say at face value, and I'm not sure how they're going to do business at that point. If I order evidentiary hearings on everything they say, it's not economic to do it. So I think the real punishment is you lose your credibility, and once you've lost that credibility, you've effectively lost the ability to do your job in an economic way.
It is somewhat of a rare occasion, but I have, and will have been on the bench 4 years in September, and I've referred 2 lawyers in that time to the bar for dishonesty.
Whoa, to the state bar?
Yep.
Because I made a mistake? I didn't mean to.
Not the first time.
Okay, so a part of the ultimate responsibility you could send them out, and maybe that lawyer could be suspended or disbarred or something else. I sat on the committee of bar examiners. We'd hear a lot of these people coming back because disbarment in California doesn't actually mean permanent disbarment. It means you're out for a while and you come back. And you always ask, what's the excuse? Do you ask, what's the excuse? Is it an innocent thing? Here's this lawyer in this case who couldn't explain or elaborate further why there was a mistake. Wouldn't you think coming into court you'd say, oh man, I had a heart attack, or my wife was sick, or the dog ate my homework, something, right?
Well, sometimes life happens. Sometimes you instruct your assistant to file the schedules which you have amended, and they never make it onto the docket, and you think they have. So I think you have to go in asking those questions. What happened? Because sometimes errors happen. Errors and omissions are human. We're human, right?
I agree. I was sitting here and I just had an epiphany, which was, it dawned on me that I mentally put a credibility score on every lawyer that comes in front of my court. And most of them are 10s, some of them are 8s, and some of them are 5s, and some of them are 3s. And the 3s are, get real scrutiny. The 10s, what they tell me I take as gospel.
It is the goal to be a 10, right?
Yeah.
Judge, go. Judge Hersher?
Oh, nothing to add.
Oh, you were smiling, though. You were thinking of a specific story.
No, I agree completely. Although I think in my ranking, I haven't encountered lawyers who have out and out lied to me. I think the ranking that I do is how certain I can be that the lawyer has been and will be diligent about the case. I have a ranking from 3 to 10 on that scale.
Wow, 3 is the lowest? That's good. It's
No.
kind of like you write your name down on a paper, you get a 40.
No, 2s
right?
and 1s get 90-11.
I always ask why this happened, and much to my surprise, sometimes I get the Fifth Amendment asserted.
No.
By a lawyer?
By a lawyer.
Nice.
Sometimes I get pushback, and sometimes I get an earnest apology. I had a recent case where there were 4 lies to one of my companion judges, violations of the automatic stay and the discharge injunction, and 5 other parties relied on the lies to violate the automatic stay. Ultimately, the lawyer was severely sanctioned. He lost his job. Everybody in the chain got sanctioned, and then everybody in the chain sued the lawyer's law firm.
This is
This
is not
follow-up-
good.
Yeah, the only follow-up I was going to give to mistakes happen and we're all human is that when a mistake does happen, to acknowledge it immediately, because I think that helps to increase that whole credibility score, right?
Right.
Yeah.
So if you find a problem, you want to cure the problem. I had a case
Own it
once
and
with
cure
a
it.
false affidavit, and I told the person on the other side, and the lawyer talks to his client, and the lawyer comes back with a declaration the next day, says, oh, whoa, we made a big old mistake, we're really
Yeah,
sorry.
And don't say my secretary made a mistake, or
Right.
don't say my paralegal made a mistake.
So you would,
That was my comment, actually.
Yeah.
Judge Barish, another judge in the panel.
That, I'm going to borrow this thing. It really, it really doesn't matter if it was your assistant or your secretary. Don't say that. It just feels to me like you're trying to throw someone under the bus. The buck stops with you. You have the license. Say I made a mistake. I apologize and move on.
Yeah, at the very least, say my office screwed up. But you ought to say, I take responsibility for this.
Is there a bright line on misrepresentations on slide 25, or is that it? Once you make a misrepresentation, you bear the burden. Is that what you're saying?
Yeah, I think what everybody has said is the best course of action is to bear up and deal with it. The way to become a 3 real easily is to lie on top of a lie or obfuscate some situation.
So wait. I got the mic back here. Professor Markell, former Judge Markell, you teach the kids now. Do you talk about this kind of stuff in school, or are you talking about the substantive stuff?
Yes.
That it? That's all you want to say?
He used to be a judge, you understand. So he
And used to be a practitioner, right?
He used to be all sorts of things, didn't you?
One of these days, I'll figure out what I want to be when I grow up, right? The point is, yes, I do talk about this because in the 9 years I was on the bench, I think I wrote about 10 disciplinary opinions. I issued a lot more that were unpublished. My students actually read them, and they come in thinking I'm a mean son of a bitch. Well, they may be right about that, but in terms of the opinions, I think you have to kind of talk. I talk about, in my world, and it was an odd world in Nevada. You had to kind of call out people who were intentionally taking lines that were detrimental to clients and were detrimental to the system. I mean, not only, for example, did you have people who would say it was my secretary. I have actually a published case in which there was a mistake made in a settlement. There were 3 properties, and there was going to be relief on 2, and they mixed up the descriptions. And when it was found out, the debtor went to the creditor and said, let's change the stipulation because the legal descriptions were off. And the creditor's attorney said, my client won't let me. We know it's a mistake. That's not what we agreed to. But my client says, I can't do this unless you have a hearing, and I'm going to make you pay for the hearing. So, there are all sorts of ways in which people can, into the system, make it more difficult for people who are honest to keep their honesty intact, and also more difficult to punish those who are not so honest. I think a lot of it, and this may not have been said, and I think it's obvious from the panel, different districts have different tolerances for behavior. And you get a culture within a district in terms of what they think is right, what they think is right. I think in 9 years, for background, I made, 12 referrals to the U.S. Attorney for crimes. None were acted on. And they were pretty much, I had one case in which the trustee stood up at a settlement and said, I have something to say here. I don't oppose the settlement. But if you take a look at the letters that the counsel has gotten to say this is settlement, he's photoshopped all the signatures. Nice. Never got prosecuted.
I took Photoshop class, and I didn't know why, but now I do. Is there a difference on truth-telling, on quality of representation among the district? Is there? Is Judge Markell right? Or do you guys have is it your
The
sense
judge is
of
right
justice?
that you create your own culture and you send messages about that which would be tolerated and not tolerated. And oftentimes, cultures need to be improved. And unless you want a miserable culture, you got to identify the things that are less than professional and raise the bar incrementally.
I think the short answer is there's no bright line rule.
It's a very odd thing, but I never, ever want to be having you put me down as a 3. I'd like to be a 10. And maybe I fall down for a second to a 9 because I'm being too overzealous and you remind me and I go back to being a 10, right? In connection with this? Yes, sir.
One thing I've always wondered about this is it possible for judges to call in privately to the attorneys first, to speak with them and say, what are you thinking? You need to straighten up before taking, the written action like that?
Wait, Mr. Bovitz, Judge Barish is on the line, and he says you're in trouble.
What I do is I have a wonderful career law clerk, and I routinely say, call these people and talk to them. I don't call them because it's an ex parte communication, and it's, I guess somebody would say contact from chambers but that's what I do. I have my
Other judges, do you contact somebody who's over the line directly or through your clerk?
I was going to say that I had heard historical stories about, before I came on the bench, that happening, the chief judge calling in a lawyer for a discussion about an apparent pattern of problems, perhaps associated with a health issue, and trying to encourage the lawyer to get help. I haven't done that. I would have a very strong aversion to doing any kind of communication with a lawyer other than in open court. So I don't have a good answer for that. If there's something that I perceive that I think might be health-related or substance abuse-related, that'd be a much more difficult situation, but I haven't encountered that yet.
I do it very carefully and make sure my clerks are there, and very gently. In our district, actually, the chief judge of the district court discourages it because there is some history of a judge who did it gently, dealing with what appears to be a mental health issue, and ended up tied up in a grievance procedure for a year.
So that's part of the reason why I would not do it. We don't have a culture in my community of those types of communications. And our culture is that if a judge can't do it, their staff can't do it either. If there were some substance or mental health issues, I would definitely pick up the phone and call the state bar. All of the state bars have lawyer assistance programs, member assistance programs, where there are peer counselors who will reach out to the affected member of the bar. And I would have no problems as a judge doing that, because it's too important to the lawyer and to their well-being and their future and their clients.
And there's usually a method of, or a level of confidentiality in those processes.
Yes, they're confidential referrals. And if you're curious, you might take a look at your state bar website. There's a ton of information, generally speaking, at least I know in my state, where people listed their names first, sometimes not even their last name, and they'll say, well, I'll talk with you about, alcohol, I'll talk with you about drugs, I'll talk with you about stress, about life balance. There's a lot of information out there for lawyers.
So there's a difference between shoddy practice and a lawyer who's fallen off the level because a lawyer has a substantive problem. And that's why I'm thinking of Mr. Bolts, who gave a fine program yesterday.
There's actually two parts of the consumer report that came out that touch on this. One is related to mental health issues that encourages the state bar programs and things like that, but that also we recommended that districts look at having some sort of intermediary public committee where the judge could send a referral to that would be short of sanctioning or a bar report or things like that, so that these issues can be taken care of without raising the concerns that a court might have about ex parte communications or things like that, but without, by giving somebody sort of a first place to fix their behavior before getting in deeper trouble.
Yeah, in our district, we just adopted a rule, and I recommend it to you. It was adopted by the district court and went into effect December 18th, 2018, and it provides, if a judge perceives that there's a competency problem or there's an impairment problem, that we can appoint a lawyer who's effectively doing their pro bono work by being on this panel to investigate and report back, and then it calls for, if there is an issue to be resolved, it calls for the establishment of a panel of judges, and if it's a bankruptcy matter, it'll include a bankruptcy judge to determine if action needs to be taken. Now, the first step in this process is, if at all possible, to go to the state disciplinary commission that has a whole mechanism for this, including a mechanism for appointing surrogate lawyers to help people who are impaired and that sort of thing. But we now do have our own system if we decide it has to be dealt with in the district court to deal with those issues.
Two quick statistics. According to the ABA, we know alcohol and addiction can be great among lawyers. It's some 25%, but they estimate that it's about 40% nationwide with respect to depression and burnout. And so that's why we're seeing the rise of these organizations, and hopefully it'll help our community.
Yeah, I made it through, so they ought to make it through, and they ought to do everything right.
It's a kinder, gentler world.
That's what the ABC stands for. Let's talk about one more case, because actually the fun part of this, really, isn't it, is we hear the judges talking. This is really the point of this. It almost doesn't matter that we've given you some really good materials that are infinitely long and we'll never get through. But they have some good examples, and they give you some of the hooks that the judges have to sanction and why. But we wanted to talk about Clink. Wes wants to talk about this because it's so great and it deals with horse stuff.
Chapter 7 case. Just before the debtor filed for bankruptcy, debtor wrote a $3,000 check to her mother as partial payment of a $5,000 loan. Counsel instructed debtor in an email that she should not send the check, but if she does, she should make sure it cannot be traced. Counsel also agrees with the debtor that they're not going to schedule her horses.
Usually the debtor says, the lawyer told me that, right? And that's usually not true. This came out on the planning panel yesterday, so you cover that. But this had actually happened. Go ahead.
Yeah, and here they've got an email. So the court's looking at the email instructing fraud on the court. Bankruptcy court sanctions counsel under 526 for advising the debtor pre-petition to file false schedules, and under 707B4 for filing the false schedules.
Go. We had a whole panel that was real good on pre-bankruptcy planning. Thank you. In connection with that yesterday. And it's really it's not a terrible thing to make sure somebody you want to get paid gets paid, though I don't know how a payment within a few days of bankruptcy to an insider is going to be, anything that's going to solve this problem. But you want to make sure that you look at that, and maybe the creditors who get a security interest do. I don't know. I could see you're smiling, Judge Hersher. Are you? Is this crazy?
It is crazy, and I think that these cases are easy for the judge to resolve and easy for us to address because the behavior is so outrageous, but it's not the day-to-day problem that we encounter. For me, it's lawyers who are just not paying attention to cases that create most of the problems.
So every creditor knows that every debtor is a liar and a cheat and is hiding money. That's what creditors think, right? And every debtor thinks those.
One of my former colleagues would say bankruptcy is the court of frauds.
But if you see something that's obviously false, okay, this person's a horse trainer and they don't have any horses on that, and you know that, or you have a feeling, what are you going to do? You just going to leave it up to the creditors to do something? You going to call the U.S. trustee and say you ought to look into it? You going to talk to the U.S. trustee?
I don't think that the judges ever, except in an extremely unusual circumstance, going to have independent knowledge about the true state of affairs of a debtor situation. I mean, the lawyer and the trustee are more likely to have that. I don't think the judge will.
I mean,
Judge Olshu is so quiet, and you have such a small district that you know stuff that's not right, don't you?
But this case right here is not a case you refer to the U.S. trustee. It's a case you refer to the U.S. attorney.
Right. This is a Title 18, criminal fraud thing. But wait, I went to this chief bankruptcy judges conference. I heard they make about 2,000 referrals, and 7 get actually prosecuted. Some infinitely small, less than 1%. That doesn't even make sense. So it's not really very effective to do that, is it? Makes you feel good.
Turns out there's a statute that requires us to make the referrals. So
there is.
That makes it easy to decide whether to do it.
Do they give you feedback on what they're doing, or is that
Not
all
at all.
secret stuff once it goes, in
Secret
that?
stuff.
It disappears.
Mr. Morocco, is there a better way for the judges and the U.S. attorney, and maybe your office to talk about referrals of bad folk?
We generally do talk about referrals. The information can go up, it doesn't come down.
Okay, so somebody over there does it. Go ahead.
I've been told that one of three things has to happen for the U.S. Attorney to act on a case. Either, one, the amount at issue has to be over $5 million. Two, you have a congressional referral. A congresswoman or a congressman makes a complaint. Or three, it makes the front page of the LA Times.
I think that's good. Judges, I told you we were going to get to a point before you knew it when we were on our last 5 minutes, and I want you each to give us a lesson, if you will, a little lesson in a row, and then I'm going to turn it over to Mr. Furr to take us out after you judges are done.
Start here. I'm surprised we've gotten this far and you haven't had the ABC advertisement. Maybe you all know this, that in the new ABI Commission, there is a recommendation that people who are ABI certified in the consumer area will get, quote, enhanced fees. I'm not sure what that means, but you know, that concept has already been in the Chapter 11 business world, but at least the ABI Commission is recommending that it go into the consumer world as well.
I think compensation is an area where lawyers can benefit, even without that change in the. I know when I was in practice, I would always make sure to mention ABC certification on a bio or even a fee application. But of course, it has the flip side of imposing a higher standard of care. But I think that's fair in the context. So that's my comment.
Are we commenting about the getting certified?
Anything you want to say.
Anything I want to talk about. Okay. Okay, perfect. Moving right along. No, communication. That's my tip to increase professionalism is communication. Most of my scheduling orders will direct people to talk before they come into the courtroom, and they often haven't talked, even though, well, they didn't used to talk. Now that they know that I enforce that, they talk. Where they would come in without speaking, I would stop the hearing and make them go out and talk and then come back and talk with me. But I think communication is so key. That's how we resolve our cases. And ultimately in bankruptcy, that's what we're doing is resolving cases. So communication.
This session, I think, has been about integrity and professionalism. And to the extent that you heighten your integrity and professionalism in any court, you're going to be more effective. It is hard to talk about sanctions. It's hard to issue sanctions. It's probably the toughest thing that we do. And if you look at the jurisprudence out of the circuits, it points out that in most circuits that the least severe sanction adequate to serve the purpose should be imposed. So while we've talked about traditional sanctions and really bad behavior, I try to find tools in the middle, admonitions, warnings, requirements you do CLE, things like that, that are going to improve integrity and professionalism. I practiced for a long time. I remember that you have to report on your application for malpractice insurance, whether or not you've been sanctioned, and your ability to get pro hac vice admission depends on whether or not you get sanctions. So while we can talk about it harshly when there's egregious behavior, it is a hard thing for us to do.
Let me say, some of the judges here, I think all of us probably agree that 95% of the attorneys do an outstanding job. And so when you ask yourself, if 95% of the attorneys are doing an outstanding job, how do you differentiate yourself from that group of professionals? And one of the best ways to do it is to get certified. It is an effective tool to differentiate yourself. And I think as a judge, it's something that, I give a lot of respect to. So I think it's a good thing. If you're in this room and you haven't done it, you ought to do it.
Thank you all very much for the comments and for the great panel. And Scott, Wes, thank you for your input here and for writing the materials. Again, have a great weekend, and thanks to everyone.
Thank you all.
Yeah, nice visiting with you.
Thank you.
Pleasure.